You spent $6,000 on a lift kit. The four-wheel drive shop fitted it, gave you a receipt, slapped a compliance plate on the firewall, and sent you on your way. I'm AJ, a TMR approved compliance engineer, and I want to have an honest conversation about what that plate actually means and what it doesn't, because a significant percentage of lifted four-wheel drives on Queensland roads right now are not in the legal configuration their owners believe them to be. This is not a scare campaign. This is the information the people selling you lift kits have a financial incentive not to give you in full. Let's start with the actual legal framework. In Queensland, vehicle modifications are governed by the Vehicle Standards and Safety Regulation, and the technical standards are drawn from the NCOP, the National Code of Practice for Light Vehicle Construction and Modification. These are not internal industry guidelines. They are the documents that determine whether your vehicle is legally registered. The headline numbers most people have heard are 50 millimeters of suspension lift without a certificate and 100 millimeters total. Here is where it immediately gets more complicated than that. The 50 millimeter allowance for suspension lift is a maximum measured above the manufacturer's standard specification, not above stock springs that were already sagging after 200,000 kilometers, above the manufacturer's specified height. If your vehicle came in under spec and you're measuring from there, you're already starting with an error. The combined 100mm figure, 50 suspension plus 50 body, only applies to vehicles with a ladder frame chassis design where a body lift is geometrically possible and structurally appropriate. Independent front suspension vehicles have different limits because the suspension kinematics change differently with lift. Monocoque vehicles have different rules again. And here is the condition that swallows both allowances. Every other modification on the vehicle must independently comply with the relevant standard at the same time. The allowances are not unconditional. They exist within a compliance framework, and that framework has requirements that most modified vehicles in the real world are not meeting. This is the concept that catches more people out than any other, and it is the one the modification industry is most consistently silent about. Stacking is what happens when you combine multiple modifications that are each individually compliant in isolation, but whose combined effect creates a vehicle that sits outside the allowable engineering limits. Every part had a compliance certificate. The vehicle as a whole does not. The most common version of this is the lift plus spacer combination. You fit a 50mm lift kit, which is within the allowance. Then you fit 25mm wheel spacers for a wider track and a more aggressive stance. The spacers came with a compliance document from the manufacturer. You now have a vehicle where the lift is compliant, the spacers are individually compliant, but the combined modification has moved the tyres contact patch outward from the original scrub radius geometry by a distance that changes the braking force vector through the steering geometry. Scrub radius is the horizontal distance between where the steering axis meets the road and the centre of the tyre contact patch. Factory vehicles are engineered with a specific scrub radius, either 0, slightly positive, or slightly negative depending on the design, because this dimension determines how the braking and cornering forces feed back through the steering. Change the scrub radius significantly, and under hard braking, the vehicle develops a steering pull. Increase it enough, and the geometry creates an understeer then snap oversteer characteristic under combined braking and cornering loads. This is not a handling preference discussion. It is a documented safety characteristic. The other common stacking failure is lift plus extended upper control arms, plus wheel spacers, plus aftermarket offset wheels, all on a vehicle that also has a bull bar, ADR, certified for the factory geometry. Each modification has paperwork. The vehicle does not meet the combined standard for any of them. A certifying engineer looking at that vehicle would not be able to sign it off. A shop that sells you each of those parts individually may never tell you that. Beyond the stacking problem, there is a separate category of lifted vehicles that have no compliance pathway at all. The vehicles fitted by someone who is not a licensed workshop, using springs bought off a classified ad or a Facebook group with no documentation of any kind. This is more common than most people want to admit. Someone buys a set of second-hand lift springs. A mate who is good with a ratchet fits them in a driveway on a Saturday afternoon. The vehicle now sits 60mm higher than stock. The owner genuinely believes it is legal because the springs came in a recognisable brands box, and the modification looks like what every second modified four-wheel drive on the road looks like. The brand name on the box is not a compliance certificate. It is a product that was manufactured to a specification. The compliance documentation, if it exists, covers the product in a specific installation context with specific other hardware by a licensed installer. A second-hand spring fitted in a driveway has none of that context and none of that documentation. What makes this worse is that it is effectively undetectable in normal driving. the vehicle looks modified. Lots of vehicles look modified. The police are not going to pull you over and measure your suspension height on the side of the road in normal circumstances. So the problem remains invisible until something goes wrong. And something going wrong does not mean a catastrophic accident. It means a routine defect inspection, a roadworthy check for transfer of ownership, or an insurance assessor looking at the vehicle after a relatively minor incident. At that point, the lack of documentation is a showstopper. The vehicle cannot be driven until it is either certified or returned to stock. And if there has been an insurance claim, the lack of documentation becomes the reason the claim is declined. Let me walk through what actually happens when a lifted vehicle without proper certification is involved in an insurance claim, because understanding this sequence changes how you think about the risk. You are on the highway, fully loaded for a long weekend away. A driver runs a red light and clips your front quarter. You are not at fault. You pull over, exchange details, call your insurer, and lodge a claim. Your insurer assigns an assessor. The assessor inspects your vehicle. They note the lift kit, the extended upper control arms, the aftermarket wheels, and the wheel spaces. They ask to see the engineer's certificate. You do not have one. At this point, your insurer is not necessarily obligated to pay the claim on your vehicle's damage. The policy contains a clause, standard across most Australian motor vehicle policies, that coverage can be voided by modifications that materially affect the vehicle's safety characteristics and that were not disclosed at the time of the policy being written. A lift kit with wheel spaces and altered steering geometry is exactly the kind of modification that clause was written for. Your insurer declines the claim on the basis of non-disclosed material modification. Now here is the part that is worse than not getting your car fixed. The other driver, the one who ran the red light, makes a claim against your third-party property insurance. That coverage may also be voided by the same non-disclosure clause. You are now personally liable for the repairs to their vehicle and any injuries sustained, without insurance coverage, regardless of the fact that they caused the accident. This is not a hypothetical edge case constructed to frighten you. It is the logical outcome of the standard policy language that most people have never read.
I want to spend some time on the engineering reality of what lifting a four-wheel drive actually does to its handling characteristics, because the discussion in the modification community is almost entirely focused on appearance and clearance, and almost never on the geometry. When you lift a vehicle, you change the relationship between the center of gravity and the roll center. The center of gravity moves upward. The roll center, the theoretical point around which the vehicle rotates during cornering, determined by the suspension geometry, can move downward, particularly on independent front suspension vehicles, where the control arm angles change with lift. The distance between these 2 points is called the roll couple, and it directly determines how aggressively the vehicle rolls in cornering. A standard Hilux at factory ride height has a roll couple designed to give predictable, manageable body roll in normal driving. Lift that vehicle 75 millimeters, and you have significantly increased the moment arm through which the center of gravity acts during cornering. The vehicle will roll more noticeably in the same corner at the same speed. Extended upper control arms partially address the suspension geometry issue, but they cannot lower the center of gravity. They can only correct the suspension kinematics. Caster angle is another geometry change that lifting creates. Caster is the rearward lean of the steering axis. It is the reason your shopping trolley wants to trail behind you. Factory caster angles are set to give the vehicle straight line stability and self-centering steering. When you lift the front of a solid axle four-wheel drive, the axle drops relative to the body and the caster angle decreases. The steering axis becomes more vertical. The result is reduced straight line stability, a tendency to wander on the highway, and reduced return to center feedback through the steering. Extended upper control arms on IFS vehicles or caster correction kits on solid axle vehicles are the engineering solution, but they need to be certified as part of the modification package. None of this means you should not lift your four-wheel drive. It means the lift changes the vehicle's dynamics in ways that need to be understood and in many cases corrected with supporting hardware. Here is the practical process that will get you a lifted four-wheel drive that is legal, insured, and actually handles well. Start with the engineer, not the shop. Before you buy a single spring, talk to a certified automotive engineer and tell them your target lift height, what tyres you want to run, and what you are going to use the vehicle for. They will tell you what the compliance pathway looks like, what hardware is required, what certification is needed, and what to watch for with your specific vehicle platform. Buy compliant hardware from a licensed installer. This is not about spending more money. A compliant lift kit installed by a licensed workshop with proper documentation does not cost significantly more than an uncertified kit. The paperwork is the product. If you are buying secondhand or installing yourself, understand that you will need engineer certification before the vehicle is legally on the road. That means a certified engineer has to inspect the vehicle in its modified state and sign it off. Budget for that from the start. Disclose everything to your insurer. Call them. Tell them what you are putting on the vehicle. Ask them what documentation they require and get written confirmation that the modification is noted and covered. That phone call takes 10 minutes and costs you nothing. Not making it could cost you everything. If you are planning a lift and want a proper pre-modification assessment of your specific vehicle platform, go to totalengineeringmods.com.au and ask Wooly to look at your numbers. It is free, it is based on the actual engineering standards, and it will tell you whether what you are planning puts you inside or outside the compliance envelope before you spend $1. Drop in the comments. What are you running and do you have the paperwork? Honest answers only. Take it easy out there.